The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to all of you, both on the Zoom or within our court Zoom call, as well as those who are watching us on our Supreme Court Live channel. I will now ask Mr. Doug Shima, the Clerk of the Kansas Appellate Courts, to please call this afternoon's docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Thursday, October 28th, 2021 consists of one case. Appeal number 123911 in the matter of Marty K. Clark, Magistrate Judge, original action and judicial discipline. Your Honor, the examiner for the Commission on Judicial Conduct has reserved 5 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, will you please state your appearances?
May it please the court, I am Todd Thompson, appearing as examiner for the Commission on Judicial Conduct, present and ready for argument.
May it please the court, Chris Joseph, appearing on behalf of Judge Marty Clark, who is also present. I'm present and ready for argument.
Thank you, counsel. Mr. Thompson, you may begin your argument.
Thank you. This proceeding arises from a recommendation for judicial discipline from the Commission on Judicial Conduct. The respondent in this matter is former Magistrate Judge Marty K. Clark from the 20th Judicial District. Judge Clark retired during his term of office after the initiation of this action. This case involves Judge Clark's participation in a website self-described as an online community for swingers, and with regard to his related activities. Judge Clark posted nude and partially nude photographs of himself and others, and gave access to others to view the photographs. Judge Clark maintained an account at this particular website on and off for multiple years. During the years of his subscription at the website, the judge paid the fees required by the website for giving access to others to the photos and information about the judge and his wife, and for gaining access to photos and information about other subscribers to the website. The website is used by subscribers for the purpose of connecting with other couples, which the judge describes as a dating website for couples. Some subscribers make connections that lead to sexual encounters. The account that was maintained by Judge Clark and his wife listed a false zip code and altered names, which we argued at the hearing before the panel revealed his awareness of the impropriety of his conduct. Judge Clark met the complainant and the complainant's wife in the late spring of 2019. They met at a bar, conversed, and after that meeting, Judge Clark and the complainant's wife began communicating via text message and email. I will refer to the complainant's wife as the judge's paramour from this point forward. The judge and his paramour discussed in very graphic terms their attraction to each other and the prospect of having sexual activities with each other. Their rather salacious texts included messages wherein Judge Clark and his paramour actually discussed the details of a wished-for sexual encounter in the judge's chambers.
Can I ask you about one of those exhibits? And I won't get into the details of the dialogue that was occurring, but it's graphic as you described. One of the questions I have is that it appears that it has a timestamp on the time in which the texting was taking place, and it says 2:16 p.m. And I assume that's in the afternoon. And then one of the text responses referred to, I should not be wound up on a Tuesday. Can we infer from that 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 was occurring during work? Or what do we take from that? And if we can, does that make a difference?
I don't know that it makes a difference, although it might make it worse. You can take that there were texts because there was evidence before the panel of the timing of the text. The text occurred during the day. The judge denied that it ever interfered with his performing his duties, but without question, they were texting back and forth during the court's business days.
Thank you.
Going on, I would note that during this discussion about having sex in his chambers, Judge Clark readily identified his chambers as being in Russell, Kansas. Photographs of Judge Clark, most of which had been stored on the subject website in the judge's profile, were admitted into evidence. Those photographs have been sealed or were sealed by the panel.
Counsel,
And, yes.
I'm sorry to interrupt you, but your time's running down. And I guess my question, I'm trying to think how to frame this appropriately. And I guess the question is, do you have any concern that this proceeding is treading inappropriately into the private life of the judge? I'm just trying to, is the recommendation of discipline and the violations entirely founded on the moral disapproval of this behavior, or is there something else? I guess that's the right question to ask.
Well, I would note for starters, this court's opinion released in February of this year, indicating that Canon 1, Rule 1.2 demands that a judge act at all times, meaning 24, and I'm quoting the opinion now, meaning 24 hours a day, 7 days a week, 365 days a year, in a manner that promotes public confidence in the independence, integrity, and impartiality of the jury or of the judiciary. And
does that, so what is the standard that we apply to entirely private behavior? I'm trying to figure out if this case has any kind of objective standard, or if this is just all of these private details, which are unpleasant, I'll say, have come to light, and it embarrasses the judicial branch, and that's the grounds on which we're going to find a violation.
Well, I would argue that these details are not private. That's why these photographs were at a public hearing. That hearing was public. The decision was made not to or to seal them so that they wouldn't be circulated in the public, but a complaint came in from a member of the public, so it's not private. Second, the judge is subjecting himself, when he engages in this type of conduct, to the possibility of being intimidated or blackmailed by people who have these photographs. In this particular instance, the complainant opted to
How far does this extend? And let's just, and again, it's unpleasant to talk about this, of course, but let's assume that a judge is having an affair, an old-fashioned affair, if I can call it that. Is that enough by itself to find a violation?
I think you probably need a little more detail, meat on the bones, but yes, I think it's quite possible.
Why do you need more? Isn't that judge also subjecting him or herself to public embarrassment blackmail, all those other kinds of things. So
Yes.
under the logic of the way this case has been prosecuted, I'm finding a hard time distinguishing that hypothetical.
Well, I don't think you need to distinguish that hypothetical. And there is case law cited in the record that says, for example, adultery in Connecticut. There's a Connecticut case cited. Adultery is not a criminal act in any way, but the court has held it still can create a situation where the judge is vulnerable, and it can create a blemish on the judiciary.
So and again, I appreciate the straightforward answer, and I'm just exploring where these lines are, but it sounds as though the position you've taken is that judges are held to, I suppose the right way to say it is the standard, the broadly acceptable standard of private behavior, especially with respect to their sexual lives. Is that a fair way to say that?
I don't know that I'd say especially with respect to their sexual life. I just think if you accept wearing the robe, you accept restrictions on how you can behave, and that you have to act.
We would all agree with that. What we're trying to discern is what those restrictions precisely are.
Well, again, it has to promote public confidence. Does this kind of behavior promote public confidence? Absolutely not. Does an as you called it, old-timey affair or old-fashioned affair promote public confidence? Absolutely not. Does it endanger the independence of the judiciary? It absolutely does. And I see my time is up.
Are there other questions?
Counsel, it used to be that drinking liquor in public was verboten. It was very dimly viewed by the public. How do we ascertain those societal mores other than simply to look within ourselves?
Well, I think you have to look into yourselves and society. You need to get out more. But I mean, we all have, they're slightly different. I'm not saying that there's a red line that is the same for everybody, but we all have standards that we think are appropriate or inappropriate behavior. And the good news is, in this particular case, we're not even close to the line. We're so far beyond the line that the panel voted unanimously. It wasn't like it was vague or uncertain here. So I don't want to get caught up in an academic discussion that is not necessary in this particular case.
But the bottom line is, the conclusion of the panel is that the conduct in question violated the code because it was so far afield from the established line, which is some moral compass. And I think the questions that I've heard today, I'm echoing perhaps, but that moral compass, are you suggesting it's just, you know it when you see it, or are there factors that can guide our discretion in identifying what that moral compass is?
Well, I don't think I use the term moral compass because I'm not sure this is just a matter of morals. I think it's something different than that. Again, I think the question is, does this kind of behavior promote the public's confidence in the judiciary, or does it detract from that? My conclusion and the panel's conclusion, it very much detracts from that. That's not a moral decision. That's an awareness of how the public reacts to this kind of behavior. Does it promote the independence and integrity of the judiciary? I mean, these are the terms from the code. Again, absolutely not. There's nothing about this behavior that makes you think this judge is above reproach, or that this judge might not be intimidated or blackmailed by someone who has possession of these photographs. So that in turn impairs that judge's potential impartiality. So all of these dominoes fall over when this behavior occurs. And again, I don't think this is just a mere where are your morals. There are some standards set forth in the code.
There are other questions. Thank you, Mr. Thompson. Mr. Joseph?
May it please the court. I believe I'm somewhat limited by the fact that Judge Clark decided not to file exceptions in this case after he retired. I do, however, want to address Justice Reggie's.
Let me just address that. No exceptions were filed. So really what we are here on is the appropriate discipline. Isn't that right, Mr. Joseph?
Unfortunately, I think that's what Rule 620 limits me to.
Well, no, it's not unfortunately. That's where we're at, isn't it?
Yeah. Well, to me, it's unfortunate because I think the court has a can of worms and the potential to set some really bad precedent.
But I want to understand the posture of the case is we're here on what is the appropriate sanction in this matter.
That's correct. Right? Okay, Rule 620D limits me to talking about, I can make a statement with respect to the disposition of the case only. I do think, Justice, and I was going to address your question, that it would be appropriate for me to answer your question.
That's fine. I you know, in preparing for this, I saw that, and my question was, seeing the time and the day in question seemed to imply that this was during possibly, or I think the assumption I had was this was during work hours.
Right, and that would provide the connection that you see in the other cases where there's discipline, some connection to workplace conduct. I just wanted to point out that is in the record. That was addressed at the panel hearing. It was not a day when Judge Clark was working. He was not in the office. It certainly wasn't established by clear and convincing evidence that he was. So I think that what you were searching for perhaps was the hook between pure morality standard and some connection to his office, and the only
I wasn't necessarily searching, it just stood out to me. Okay, thank you.
Understood. So because of Rule 620, I am limited, as you mentioned, just talking about disposition, and the only comments I have is, I mean, he has since retired, so removal and suspension become irrelevant. The panel recommended public censure.
Mr. Joseph,
Yes.
Do you have a position on whether or not this court has jurisdiction to impose any discipline, including censure, on a person who is no longer a judge?
It's a good question. Being limited by 620, I didn't plan on researching or arguing.
Well, to me, that's entirely within the ambit of discipline.
Yeah.
And I think it's an important question whether or not someone who's no longer a judge, because the code, by its terms at least, only applies to judges. It doesn't apply to retired.
Right. And particularly Judge Clark is not an attorney as well. He is a lay judge. So he is done. He's not going to practice. You can't. Some judges, there's a concern if they leave the bench, then become a practicing lawyer. And that is a hook, if you will, to keep jurisdiction over him. That would not be present in this case. Judge Clark is retired and not returning to the practice of law because he's not a licensed lawyer. I think the court can do whatever it wants to do under the rule. You can find no violation and dismiss it. You can impose any of the discipline options, or you can find there's no jurisdiction because he has since retired and is no longer, there's no possible future conduct. So yes, I agree that is an issue. One which I didn't brief again because we didn't file anything. We didn't have any exceptions to make. My only suggestion in terms of disposition, if the court does accept the panel's recommendation for public censure, I would encourage the court to craft this in a way that does not set precedent that becomes an unfortunate precedent for future issues that might come before the panel. on questions of morality. I think Justice Wilson pointed out correctly that drinking was a moral objection. Homosexuality was a moral objection, both of which you could write language following this panel's rulings that could create something that's troubling for future generations based on what I see to be a reasonable person standard the panel suggests for determining morality. So whatever you do, my only suggestion, if you take the public censure route, to craft this in a narrow way that does not create problems for things that may seem problematic to a reasonable person in 2021, such as drinking or homosexuality used to be a problem morality-wise 30, 40, 50 years ago. I don't want the court to create something that's a problem for us, the generation appearing, my kids appearing before the court in 2050.
Counsel,
But go ahead, Justice Wilson.
Counsel, but isn't it appropriate for the court to look at what the societal mores and expectations and accoutrements are at this time, as opposed to what they were 50 years ago?
So the issue to me is when is discipline appropriate? And I presented my arguments to the panel and they disagreed. But my response to you would be the same as was to the panel, which is you don't know. I don't think you look at morality as a basis, especially some of these private sexual morality as a basis for discipline, unless, like these other cases, and why I referenced Justice Rosen's question, unless there is a connection to the job. And you'll see all the cases cited in the briefing. You know, there's always some kind of hook to that, you know, such as pornography while at work, such as saying something to a clerk or showing a picture to a clerk who works for the court. There, you know, things that aren't present in this case because that Tuesday was not a work day.
I think, counsel, mores are different from morality. I think mores is a broader concept of just general expectations of how society expects people to act and whether or not there's some objective line or some clue that we can use.
It's dangerous to try to do that. I'm not. My position is the court shouldn't venture into that realm. It's dangerous to do. You know, again, 50 years ago, homosexuality would have offended most folks in society, and it shouldn't. It should not be a basis if it is a private life with no hook to his role as a judge. Again, I don't want to try to tread upon Rule 620 and try to backdoor in arguments because we did accept. We did not file exceptions. But I do think it's a slippery slope. So to the extent that you do craft public censure, I do worry about setting precedent that becomes a problem. That this reasonable person standard is awfully difficult to apply. And who is the reasonable person? Is the reasonable person a member of a small religious community in Southwest Kansas? Is it the broad state of Kansas? Who is this reasonable person that sets these mores or morality standards? And I don't know that you can do that. It does become a slippery slope issue.
I appreciate that you're trying hard not to tread beyond where you should go, but maybe our questions are pushing you that way. And since there's time on the clock,
Sure.
The question occurs to me, it's a policy question really. When we ask these questions of mores or morality, does it make a difference that this judicial position is a publicly elected one?
Well, you'll see in the case law, there are many of the cases that were cited and discussed in our briefing where, for example, Pennsylvania and some other courts who have considered affairs and morality suggested that there should be a line that doesn't go to this particular question. It just shouldn't be part of discipline because these are better resolved at the ballot box. For example,
Right. The idea is if his constituents don't like it, they can vote him out.
Right. And several courts have taken that position. It seems informed. I like that position. The other position that I like quite a bit is that without some kind of hook that ties the conduct into the judiciary, you shouldn't be going there at all. In this case, you had a complaint by a resident of Missouri. It's not, there's no conduct that involved work. Because of that, if that Tuesday at 2:16 If Mr. Thompson had established by clear and convincing evidence that Judge Clark was working that day, you'd have that hook. You'd have something there, but he wasn't there. It was a private personal phone. He was out of the office. There really is no connection other than the woman with whom he did not actually have an affair, suggesting something would be some fantasy of being in chambers at one point, again, on his private personal phone text message. So there's no hook that ties it into his role as a judge. And frankly, yeah, when you're looking at strictly questions of morality, those can be resolved at the ballot box, or otherwise if he is out of sync with the standards of his community.
Counsel, in Ray Romy, the judge made fun of a prostitute during sentencing by giving her sentencing in verse. And in that case, it was found that that behavior was so egregious that he was removed from office. Later on, he was elected by the voters to that very office. So I would argue that both the court and the voters exercised their discretion in attempting to do their job as they saw fit. Can you distinguish that case from this situation?
Yeah, absolutely, because what you've described again is conduct related to his performance of his job. If Judge Clark had made inappropriate comments, not even just in chambers, but at the courthouse, there's something tying it into the job. Here it is completely private, personal, out of court behavior. There's nothing tying it into his role as a judge. He didn't even do it during the work hours. This is regulating the bedroom, essentially.
I have a question. Let's take morality out of it. Okay. Let's not even talk about morals. Let's talk about that the complainant in this case opted to file a complaint instead of posting this picture that he had in his possession of the judge naked or body parts, and instead posted that on his Instagram account and it went viral. Does that affect, as the code says, public confidence in the judiciary or promoting integrity?
That really gets into the blackmail issue, if you will. I mean, I'm not
talking about blackmail. I'm talking about the reflection on the judiciary. And you could say also, if I post a tweet that says F the president.
Sure.
In my own time, on my own phone, on my own private Twitter account. Does that reflect well on the judiciary? Does that promote integrity and public confidence in the judiciary?
No, I agree that's a bad set of facts and you don't want that. Likewise, if somebody hacked into your phone and took one of your private pictures off, which unfortunately can happen, and posted that, that would be...
What happened here
I
was
understand.
Intentional putting out there
Sure.
for public dissemination.
No, it was as if I sent a naked picture to my wife.
Isn't it foreseeable? Well, no. Wouldn't it be
is.
foreseeable that somebody would, don't we do that all the time on social media? Realize that if you post something, it's out there.
This was not on social media. This was
But if you text something, the old adage of don't write anything down that you wouldn't want on the front page of the Wichita Eagle.
I agree. It is risky in the sense, but it's also likewise risky if you send a naked picture to your wife. The same risk attaches. I mean,
right.
This very well could have. I mean, whether or not it is. I mean, it's essentially what you tell your kids. Don't take naked pictures of yourself. Don't do these things because don't write an email. No, I agree with that. It's not wise because there can be issues. That said, where does the court come in? If it wasn't posted anywhere, the only reason this became a matter of public knowledge is because it went to hearing, and here we are. Otherwise, it wouldn't have been.
A member of the public complained about it.
Yeah, to Mr. Thompson, who put the pictures in the record. Yeah, otherwise nobody would have heard about it.
Well, wait a minute, counsel. That's not the finding of the panel. At the top of page 12 of the final hearing report, it says the respondent's decision to take a picture of his penis and post that picture on a social media website crossed that bright line and violated the judicial canons, requiring a judge to act with integrity. And earlier in the decision, the panel specifically rejected your argument that this was not public. And so this case has got to boil down, based on the findings, to being the posting of these private pictures on social media that was more widely available than just you're sending a picture to your wife. And that's why I think so much of this discussion is off base.
I'd push back on that, Justice. I don't think those aren't the facts. I mean, literally, it is a website, but the only people that had access to this was the respondent and his wife. I mean, so it literally, you have to grant access. These are the facts in the record. The panel characterized it, and I see the language you're talking about. I mean, they're calling it a social. The only people, if you go to the record and the facts, the only people that have access to this, the respondent and his wife. Nobody else can have access to this.
And those to whom they gave consent to have it released to you, is that correct?
The respondent and the wife, yes. The respondent and his wife, or not the respondent, I'm sorry. The complainant and his wife were given access by the respondent and his wife. So Judge Clark gave authority to the complainant's wife and the complainant to access the photograph. So this is two couples that had access to it.
And this is, so at the top of page 11, the panel specifically says the respondent cannot hide behind a claim that these were not public because he was the only person who could give permission. The respondent opened the door by releasing the photos to even one person on social media. Those photos could be generally disseminated to social media world and even finding their way to the commission. So I think really both sides keep wanting to keep talking about moral compasses and moral codes. This case has got to boil down to the fact of using social media for this function.
Those aren't the facts, Justice. I mean, it's the same. I read the language that they're using in there to mean, I mean, they didn't change the facts. Those are the facts. What I read that paragraph is saying is the same as I'm creating the ability to, if I send a naked picture to my wife and she gets mad at me and files for divorce, and that's the revenge porn legislation that's out there, she could then post it on Twitter. You're creating this
Mr. Joseph,
same scenario.
Justice Biles drew our attention to the exact language in the from the panel that I have at least conceptual concern with, the language about you respondent can't hide behind the notion that this wasn't public. I'm wondering if that's even right as a matter of law, because that standard suggests that there's no such thing as privacy at all in any two-way communication. So every email I've ever sent, every text message I've ever sent is now public. I don't know how we escape that conclusion from the panel's conclusion, and that would be very troubling to me.
I think you can use the same language, and this is what I said to the panel. Again, they didn't agree with me, so I acknowledge that. You can use the same language and same description if I send a naked picture of myself to my wife by text and she later posted.
Well, it might help to take naked pictures out of the, what if I just say, I'll meet you for lunch at 12 p.m. at the Classic Bean or wherever, downtown Topeka. And I send that to whomever in a private text or email. According to the panel's findings, that email is public, right? Would you agree or disagree?
No, I agree. No, I agree. Anything you send, there's a potential that it can be, I'm essentially saying the potential that it is later disseminated exists. You put it in writing, you send it to someone, therefore it could be disseminated on a public forum later. That everything's that way, whether or not it's a naked picture or I'll meet you for lunch. It is a communication, while private between two people. It could be later revealed to the public at large. You cannot hide behind that, if you will, is the conclusion of the panel.
Mr. Joseph, I assume from your argument that your recommendation of the court would be to impose no discipline?
Yes, yes, it would be.
Just to make that clear. Are there
Thank you.
other questions? Mr. Thompson, you reserve 5 minutes.
Thank you. There's been a discussion about bad precedent or precedent that would cause a problem in the future. If you rule that this behavior does not require discipline, that's bad precedent. That will cause problems in the future. Justice Stegall, I would respond to your suggestion, your hypothetical suggestion that this is very different. The whole purpose of this particular website is to send your photos, these nude photos, out to other people who you don't really know. So this is not the same as sending a message to your wife saying, let's have lunch at the Classic Bean. This is completely different.
Do we have to, and I appreciate that difference, and that's a point worth exploring, because I think this, where we draw the line between public and private is, at least from my perspective, one of the most important things about this particular case, because it has such wide-ranging implications for society and certainly for members of the judiciary. And so my question is, you're essentially suggesting that there should be some kind of a foreseeability element to this. Like, if I make a private communication, you have to sort of assess the risk level of exposure. That's kind of what you're saying, right?
Well, I still would refer to, I think one of the other courts talked about the fact that all of these other issues aside, when a judge is grooming his private organs for purposes of taking a photograph and then takes those photographs and tries to claim that they just accidentally slipped off out of his phone when he was talking to a woman, that there's just no justification for that as being private. That goes beyond private. The whole point of taking those pictures is not for him to look at himself. He took those pictures to give to other people. And the same would be true.
But it seemed as though the panel drew such a wide net to what is public by anytime anything is shared at all. And I certainly, you won't get any argument from me about the disturbing nature of the conduct here, but I'm having a hard time seeing how we draw the public-private distinction based on the content of the communication. It seems to me the content of the communication cannot play a role in deciding whether it's private.
Well, I would say the content can, because in this particular case, there are gross, vivid descriptions about having sex in chambers. Now, that is related to the judiciary directly and absolutely. That's not a private matter. So the content does relate to whether it's public or private. And I would encourage you, before this opinion gets written, to go back and read those text messages about sex in the chambers and ask yourself, is this a private matter? This is with a lay person in which he tells her where, from another state, which he tells her where his chambers are, and then they talk vividly about what would happen if they were together in chambers. So I also heard a photograph as a phrase. There was not a photograph. There were a multitude of photographs, multiple photographs. So this wasn't the case of sending a photograph out. There were multiple photographs of both men and women sent back and forth by this judge to and from this judge. So I would suggest this. The panel has recommended public censure. That's the absolute minimum that is required here. I would also note that the respondent is in his early 50s. He has the ability to run for this position again. which would be unfathomable to me. I understand the Romy situation, but in this particular instance, I'm not sure just admonishment is appropriate. I would suggest that there be some additional criteria applied that would preclude him from ever being a judge again unless he has had a great deal of education about the role and about the integrity of the judiciary. Thank you.
Mr. Thompson, your last remarks kind of, I think, tell me the answer to my question. But again, I'm focused at the top of page 12 of the final hearing report that talks about posting, and it just says a picture, but I don't care about that. But post the social media website. If you take the social media website out of this case, do you still have an argument for public censure of this judge?
Well, I would argue this is a social media website. It's not an unlimited one, but it is a social media website.
Take it out of the picture.
Okay, so if it's
that didn't happen.
Well, he still distributed photographs to members of the public of himself, of his genitals, to people he didn't really know. Initially, he posted these pictures and gave this couple the right to access them after meeting them one time. So yes, it's still inappropriate behavior. Just taking pictures of your genitals and distributing them in any way to the public, in my opinion, does nothing to enhance the integrity of the judiciary.
Are there other questions?
I did just have a quick question that I remembered as you were closing. But what is your position on the jurisdiction now that the judge has voluntarily retired?
I think the jurisdiction question was answered in Henderson 2 very clearly by this court. If I can grab that real quickly, I'll quote you guys in holding that the judge should not be able to escape by simply retiring. The respondent, this is your quote in Henderson 2. The respondent suggests this court lost jurisdiction over him as a result of his resignation from his judicial office. This argument is inconsistent with prior decisions of this court and with the policies that govern the discipline of judges. So, and then it goes on, you go on to cite other cases.
We also found
you clearly have jurisdiction.
We also found that because Judge Henderson was no longer serving as a judge, we lost the capacity to sanction him.
Well, no, you lost the capacity to remove him from office.
To suspend or to sanction him out, and we didn't do anything else.
Yeah, there was no sanction imposed.
Correct.
Mr. Thompson, your proposed discipline raises a question of, in my mind, of what authority there is that a Supreme Court has the ability to bar anyone from future office.
I think it does raise that question. I don't believe that question has been answered, although the code specifically states that you may impose any other remedy that justice requires.
Are there other questions? All right. Thank you for your arguments today. The court will take this matter under advisement. And the court is in recess until 9 a.m. tomorrow.